Good morning. How are you today? Well, it's a beautiful day out, and there are all sorts of developments in the Chauvin trial in Minneapolis. The defense is working overtime in an uphill battle, given the powerful evidence that the prosecution has. And I think it continues to be the case that the only angle that the defense has is to catch a juror that was biased and got through the jury selection process, voir dire as they say it, to ask questions, and who would be susceptible to the defense that one, this was a powerful man on drugs, and he used only necessary force. I'm not saying I believe this, by the way, and that the drugs in his system made him more powerful than usual, and that he basically chose to put himself at risk by what he put in his body. Now, it's kind of a thin gruel from the evidence to get to that argument. But if you have a biased juror, then you could hang the jury with it. Now, what is the defense against a biased juror? Well, that the evidence doesn't even come close. And let's analyze a couple of these things. We had an emergency physician yesterday talk about how the presence of fentanyl and an opiate in his system could cause asphyxia, which could cause his death. Now, the two things they didn't talk about were what was the quantity of it in his system in the toxicological report, and what was the likelihood that it did have effect. And we're going to hear a lot of experts about that, so that's coming. That'll be the last week of the trial. I think it's unfortunate the prosecutor called that witness, because I don't think there was any question that he died as a result of what happened out on the street. So that piece of that testimony, if it was going to come in, why not let the defense put it in so you could cross-examine the witness about it? So I didn't understand that, but I haven't been watching wall to wall what's been going on, because I have my own clients to take care of. The second piece that's interesting to me is that following this same theme, the defense sought to bring into court and override a Fifth Amendment defense to speaking at all in court by the fellow who was in the car with George Floyd, and who allegedly supplied him some drugs which he immediately popped in that place, and to have him testify about his condition, being sleepy in the car. Now, there's already somebody from the store that's contradicted that part of the possible testimony. To my surprise, the judge is considering giving the person limited protection from the Fifth Amendment, and perhaps having him answer a question. He hasn't made a decision yet. I think that's a dangerous decision. I don't think you can basically get around his assertion of a Fifth Amendment, not rightly so. Now, the irony, of course, is the prosecution is not interested in having him testify, and they are in a peculiar position, because they could immunize the witness, say he wasn't going to be prosecuted, and then make him available both to the prosecution and the defense. I don't think I would do that, but and I don't think this prosecutor is going to do that. And the judge may commit an error against the quote drug dealer, if you will. So that's another part of the case. We also had a witness today who basically described under what circumstances one could use force, and he kind of batted away by what the defense asked him. Some of the things that we presume are violent and too far. Now, the prosecution did try to clean it up a little bit, but it's not clear to me why they put such a witness on the stand. I don't get the theory of the prosecution sometimes. They have overwhelming evidence. I think they're over-trying the case, and I hope that they don't turn the expert testimony into a circus. Because if the jury's only focusing on that, while most of the jury will go for a conviction, you're feeding that defense for that one juror who may be biased. Now, I don't know that there is a biased juror, so this may just be an unnecessary concern. But you have to sort of assume the worst case. I had a judge once in which I kept pressing for a question to be answered, and the judge kept sustaining the objection. And there were multiple defendants in the case, and one defendant set up the situation in which I thought I had to question the witness, but the others didn't make that question, and they were busy objecting to me asking it. And the judge liked me, and there was a break, and during the break, he put his hand on my shoulder, and he says, "John, you don't need that evidence." And I said, "Your Honor, if I knew what the jury was thinking, that would be okay. And you tell me what you're thinking, but they haven't told me, so I try to ask that question." Well, the jurors, I did ask them after the case was over, and we did get a conviction. I asked them what they thought about that question, and they wanted to know why he wouldn't let me answer it. And I did talk to the witness, and the answer might not have been that good. So a trial is really that. You're in suspense however much you know. Now, I don't think there's a lot of suspense about the fact that the defendant should be convicted based on the record before the court. And I do think these efforts at a defense are not going to pay off, but you don't know. And so if you keep on your discipline, you increase the chances as a prosecutor of winning and not having a hung jury. So that's basically my thinking today about that. There's a lot else going on, but this interests me. So I hope you have a good day. Hope you get out. We'll talk to you tomorrow. Bye-bye.